Now, we all heard Lisa tell the ladies at her dismissal lunch or her clarity lunch that all of her lawsuits are either dismissed or on their way to being dismissed. And now, I don't know when that was filmed, but as of October 26, 2025, that is not the case. She does still have a lawsuit that is still in active litigation, so let's talk about it. Bart Carlson and Yukon Construction are suing Lisa Barlow, Vida Tequila, and Luxe Marketing. Bart is the president of Yukon Construction, and as we all know, Vida and Luxe are both Lisa Barlow's companies. In his complaint, Carlson alleges that Lisa Barlow reached out to him and let him know that she and her companies, Vida and Luxe, were experiencing some severe financial difficulties, and she requested that he loan her money on an ongoing basis so that she could take care of some personal and business expenses. Carlson agreed to either personally loan or cause Yukon to loan the funds on an ongoing basis on the terms agreed upon by Carlson individually and on behalf of Yukon, and Barlow individually and in her capacity as principal of Luxe and Vida Tequila. Pursuant to the loan agreement, the plaintiffs would loan funds to the defendants in amounts specified by Barlow, and the defendants would agree to repay the loans upon Yukon, Carlson, the plaintiffs' demand. They purposefully did not specify a time period within which the plaintiffs must demand repayment of the loans. Carlson states in his complaint that they agreed to the loan agreement's flexible terms because of his longtime friendship with Lisa Barlow and her family. Beginning on or about May 22, 2010 and continuing through June 22, 2011, Yukon loaned the defendant Lisa Barlow a total of $171,836.37 pursuant to the loan agreement and in accordance with this table. Payments that were made to Matthew Kober were to be used for Vida Tequila's procurement of product and other minor business expenses, and payments that were made to Ballard Spahr, which was a law firm that rendered legal services to Vida Tequila in exchange for legal fees. Those payments were to be made to Ballard Spahr for the cost of the legal services they provided. The complaint also states that payments were to be made directly to Matthew Kober or to Ballard Spahr instead of Vida Tequila itself because she desired that her husband, John Barlow, was not aware that Vida Tequila lacked sufficient funds to pay its expenses. Beginning September 10th, 2010, and through October 9th, 2015, Carlson individually loaned the defendants a total of $87,100 pursuant to the loan agreement and in accordance with this table. Payments made to Eduardo and Alessandro were for work that they performed on Lisa Barlow's personal residence for which she owed them money. Payments made to Kober or Kober Law were to be used for Vida Tequila's procurement of product as well as to cover other minor business expenses, and these were to be paid directly to Kober and Alessandro and Eduardo for the same reasons before, which is that Lisa did not want John Barlow to know that Vida Tequila did not have sufficient funds. Beginning in 2011, the plaintiffs made payments on an American Express card issued in Lisa Barlow's name, but residing with and managed under Carlson's personal American Express account. Carlson says that he issued this Amex so that he could more precisely track expenses that Barlow and Vida Tequila incurred. Between 2011 and 2017, plaintiffs say that they paid $119,585.99 to the Amex for charges associated with Lisa Barlow and Vida Tequila. Between May 22, 2010 and February 1, 2018, the plaintiffs loaned the defendant $410,842.36. That is a lot of money. Carlson reached out to Lisa multiple times in an effort to get this loan repaid, and each time she replied with something even more ridiculous, in my opinion. The first time he asked her if she could pay or if she could wire money once they closed the line of equity on their home, and she replied to him with a palm face emoji saying overwhelmed. The second time, when he texted her April of 2020, he asked, did she close the loan or can she pay back something? And she said, no, they didn't have it. In September 15th of 2020, Carlson called and left a voicemail and then sent a text following up asking for repayment of the loan. And she just said, let me see what we have. I feel so overwhelmed. Let me look. Too many Zooms, KK. In 2022, Carlson reached out to Lisa Barlow for the last time, asking for repayment of the loan or if they could simply discuss the money that he had loaned her over the years, and that didn't end up happening. So on March 8th of 2024, the plaintiffs formally demanded full repayment of the loan. And at the time this complaint was filed on June 19th of 2024, the full amount of the loan was still outstanding. This complaint has 4 claims for relief against the defendants. The first is breach of contract. The second is breach of implied covenant of good faith and fair dealing. The third is unjust enrichment, quasi-contract, quantum merit. And the fourth is declaratory judgment. The plaintiffs ask for an award no less than the total loan amount. They'd also like attorney fees and costs in accordance with Utah law, as well as further relief that the court deems necessary, just, and proper. They would also like a jury trial.